You're listening to the Privacy Casebook Diary.
And in each episode, we discuss and review a data protection case or matter.
We hope you enjoy the content we share.
And hopefully, you'll learn and grow together with us.
Hi, I'm Cristina from CVG Solutions, a multi-award GDPR consulting business. We do everything that is data protection related.
Hi, and I'm Michael Mulholland from Spencer West Law, which is a multi-service law firm. And I specialise in data protection, like Cristina.
Okay, so today, Michael, we're going to be talking about a really interesting case. In fact, you've written an article about it. Do you want to take it forward?
Yeah, so this is Farley, which is and the Paymaster 1836, which is Equiniti, the firm Equiniti, and I have written an article which is on the Spencer West website. So this is about the pension benefits of the annual benefit statement, which gets sent out to the members or the policyholders. And in this case, there was 750 letters were sent out, a bit of a customer service catastrophe, and they were misaddressed. So there's potential complaints from 750 Sussex police officers, and they were sent out to out-of-date addresses. So in customer services parlance, then you have people who are known as gonaways. So they may have moved houses and they've not informed, could be their banks or insurance company or utility providers. So that means that customer service departments hold incorrect information. And obviously that's one of the principles to keep data up to date and accurate. But it is a problem because then customer services department, these guys are called gonaways, who need to employ tracing agent services to update their records. So maintaining customer records is always an ongoing issue, and to maintain that quality. So here, 400 police officers brought claims into the GDPR and the UK Data Protection Act 2018. And they cited distress, anxiety, and in some other cases, psychiatric injury.
Wow. Okay, that's serious.
Yeah, it is. So, I mean, I've had experience of this when I've supported customer service departments. And when you categorize it, it's like if you take a step back as a DPO, you say, well, what's the real damage here? So there's someone's pension statement's gone out. If he goes to the next door neighbour and they opened it up, they go, oh, okay. Oh, wow, he's worth quite a bit of money. So there's some intrusion.
Yeah.
But they call the categorization is that, but if the post is returned and it's unopened, that would be categorized as a near miss.
Right.
And in terms of breach reporting, so, well, actually, it wasn't a breach because they didn't actually, the envelope wasn't opened.
Right.
But this case now, Farley, I think changes all that. And so I think customer services department, risk departments, and the breach reporting procedures will all need to be reconsidered, because this case is saying, even if the post is not opened, that's still a GDPR infringement, because you're processing the data and it needs to be processed lawfully and securely.
Yeah.
And the onus of proof then is not on the data subject to prove that it hasn't been opened or their data's been compromised. It's on the organization. So if the organization makes an error and sends out the data to the wrong address, that's on them.
And in fact, you know, your article states that the Court of Appeal has actually lowered the threshold to claim for non-material damage for mishandling this data. So it recognizes the distress that is caused from using, you know, inappropriate or incorrect data, even without a third party accessing it, without the proof of third party accessing it. So actually, that it's quite an interesting outcome, if you want, because it redefine, what is a near miss, actually, doesn't it?
Yeah.
And so this could potentially lead for organization to review their, data breach processes, categorization, data breach procedures, how you capture it. But my question would be, obviously we're talking about post here, the actual physical post in this case. But what how do we translate that into the electronic scenario? So if I say that I'm sending an email to James Smith, and actually I was supposed to send it to Jane Edwards, and because I got quickly and I used the wrong address, and I've got a delay in my email by 3 minutes, and I realize I've done that, so quickly I go into my Outlook, my outbox, and stop it. So is that a near miss? Do I need to record that? You see what I mean? And if I do, how realistic is that? Because we do that quite, sometimes more than once a day. That kind of so because obviously sending an email to the wrong email address, it's one of the highest causes of data breaches. But is it realistic to record?
Well, I think the same thing would apply. So even if it was Lord Justice Warby who gave his decision in the Farley.
Yeah,
Uh, I think the same thing would apply. So even if I think he mentioned, like, if you leave your laptop unencrypted on a bus,
yes,
so encrypted, I mean, on a bus or a train,
yes,
and this would still
consider a near
that
miss.
still akin to what the decision here, because you don't have to show a threshold. So even so the risk might be minimum, or highly of data breach might be, yeah, it would still, it still has got potential to cause some distress. So electronic means, I think that would the same thing would apply. So if you sent the even if the document in there was encrypted and they needed a password to access it, that would still constitute a breach. Um, so the definition of what a near miss is now, is there going to be such a thing after this case?
Well, yes, because if you are using data unlawfully,
Mm.
then that is a breach.
It's a breach. Yeah, that's it. So can you categorize anything as a near miss?
Yeah,
If it
I'm
goes to
just,
the wrong recipient. So if it goes to the wrong recipient in any circumstances, is that's a breach. You've infringed your duties as a data controller,
yes.
and that's on you. You know. So
I'm just, I'm just, I don't know how practically or how practical it would be to actually record in from a digital perspective near misses in terms of emails that have not gone to the wrong recipient because they got caught before that, in an organization that has
oh,
hundreds of employees. How are they going, do you know what I mean? How practical would that be to
are you
record?
saying that the wrong recipient hasn't received the email?
No, so you catch before it goes. Is that still considered a near miss?
I wouldn't have thought. Oh, yeah, that might be a near miss then. I think because we almost sent it out, and we intervened in time. So there you go. There's an example where I would think
Yeah.
that would constitute a near miss, but it didn't actually reach the unintended recipient. So I
Yeah.
think that
But
that would
yeah,
be
the
okay.
point is that, when you how practically can you get that done? Can you capture that near miss in an organization that has, various employees? It is
Oh, so
not
sometimes you might send off the email. You've sent off the email, and it's not been opened by the other side, and then you've got the facility, haven't you, on Outlook or whatever, to recall the email that
yes.
you've sent. So that potentially would be a near miss, I
So
think.
that would be a near
So if
miss.
you open it, if you return it before, or you stop it being
Yes.
open,
But
or you
but
intervene beforehand.
say that, Michael, you want to send me an email, or sorry, you want to send someone an email, without any attachment, but by mistake, you're sending it to me, okay? And it goes into your outbox, okay? And then you realize, oh my God, I've put the wrong email address in it. So you go to your outbox and you retrieve it. So you stop it from going out. So it never
Yes,
comes to me. I'm not aware of it. So there's no damage done. Is that a near miss?
I would have thought so because you've intervened in time before the damage is done and it hasn't reached the recipient.
Okay.
So that I would count that as a near miss.
Wow.
Um,
Okay. So,
so
so organization got, they've got real lot of, oh my God, this is huge.
I think it is potentially huge. Yeah. Um, so the council for Equiniti argued that you've got these so the 400 police officers that so there's been mismailed, and the High Court um, own, had proof that 14 of the letters were open. So they said, you guys can stay. We'll consider you've got a case here that you
Yeah.
can make. But the council for Equiniti is saying, well, these are police officers. The nature of their job is that they should be robust and resilient. So is it really um, likely, given the nature of what they do, that they're going to suffer some distress and some sort of psychiatric injury because their pension statement has gone
Ah,
askew and gone
okay.
awry? That was the argument, but that was so. But Warby picked that up and saying, well, it's not. It's potentially it could cause distress. So each case needs to be considered individually on its merit. So here, there's 400 police officers made the complaint, over 400. So that means there's going to be potentially a lot of time and effort considering each case on an individual basis by customer service teams or legal teams to consider what the real damage is. So,
Also,
and
the one, sorry,
yeah,
Michael, because only
yeah,
14, they said, you can go ahead because your letter was opened by a third party. But now that
yeah,
the Court of Appeal has lowered the threshold, then the
yes,
other remaining can now appeal again. And so to say,
that's right.
yeah, oh,
That's right.
wow.
Wow. So that makes a big difference, doesn't it? That's
Yeah,
right. So yeah, so they claimed Article 82 of the UK GDPR, so which looks at what type of damages you claim. So if it's material damages, that would be some like financial pecuniary loss.
yeah,
But here, this is the right to claim non-material damages. So this is uh, injury to feelings,
yeah.
distress, uh,
Anxiety.
psychiatric anxiety. So maybe so. This is where this is caught, and it aligns. There's an Austrian post office decision where the post office were responsible for analysing uh, customer data and profiling in terms of finding an indication of their political persuasion. So one member took sued the post office for €1,000, and initially that was rejected, but then it went to the European Court of Justice, and again it just showed that there's a no threshold or to bring a claim, but so they could consider the claim for distress for distress in the matter. So what Farley's done is bring us in line with European Union jurisprudence, and we're following that. So it's a great news for data subjects, but it's a bit of an operational headache for customer services departments. So I think that's the long and short of it.
Yeah, so
So
I mean, I'm
yeah,
now going to have to go back to all of my clients and sort of relook at their data breach procedures, and how to start recording, those near misses. Some are practical, but some are not practical, and I'm not sure how we're going to go about that yet.
Yeah, I think the procedures will have to be looked at and then rewritten and maybe reference this case.
Yes.
And in terms of breaches, then what would have been, well, we've had a data breach for 14 people. Now it'll become 400, for
Mm.
example,
Yes.
or even more actually, because potentially the original breach for the Sussex police officers was 750. So
Yeah.
we've had a breach of 750 people. So
Wow.
yeah. So fortunately for me, at the moment, I'm not a head of operations or a head of customer services, but that's something that someone would need to look at. But
Well,
obviously, we can advise on that, can't we, Christina?
yes,
If we
I mean,
need
yes,
to.
we do DPO services, so we very much work quite closely with the business. And so yeah, it's definitely, DPOs are gonna be busy as well, but yeah.
Yeah. So I think that's it, really. I think it's going to be a bit of a slow burner, but I think um, it shouldn't be. I think organisations will need to pick up this case very very quickly and then look at amending the data protection policies and the breach reporting procedures and their risk analysis and
Yes.
to properly define this.
Yes.
Okay.
Wow. Thank you very much, Michael. Speak soon.
Thank you, Christina.
Bye.
Okay. Till the next one.
Yeah.
Bye.
Bye.